Thank you all for taking time out of your day to attend Equal Justice Works webinar on the immigration implications of the 2016 election. My name is Laura Morsek, and I'm a portfolio manager of fellowships here at Equal Justice Works, and I'm joined here by my colleague Katsia Naki, who is program manager of our Justice AmeriCorps program. And Katsia and I have organized today's webinar in order to bring together immigration advocates within our network, including our current fellows, paralegals, alums of our programs, host organizations, and funders to discuss the broad-ranging implications of this election. So we really hope that this webinar will be the beginning of broader initiatives to convene our constituents to share ideas, discuss best practices, and leverage resources to protect the rights of immigrant communities. So we've brought together a wonderful panel of experts who will start a discussion on the foreseeable consequences of the election relating to various forms of immigration relief and enforcement priorities. Our panelists include Royce Bernstein Murray, the Policy Director at American Immigration Council, Jill Marie Busey, Advocacy Attorney at Catholic Legal Immigration Network, Jennifer Podkull, Director of Policy at Kids in Need of Defense and who's also an Equal Justice Works alum, Aideen Castillo, Attorney at Centro Legal de la Raza, one of our host organizations for our DACA Corps, and Adina Applebaum, current Equal Justice Works Fellow who's sponsored by the Arnold and Porter Foundation at CARE Coalition. So I'm going to turn it over to Katsia for some housekeeping notes.
Hi, everyone. Thank you so much for joining us again this afternoon. Just some quick notes, and I will make some quick logistic notes as well before we start the Q&A. Right now, we have everybody on mute, and we're going to allow the presenters to give their presentations, and then we'll open it up for Q&A, at which time we will unmute the lines and let folks have the opportunity to ask some questions of our presenters and to engage in some discussion with one another. We are going to please bear with us. There'll be some slight delays in between the presenters, just as we're changing speakers using our webinar system. So just bear with us for that. So with that, I'm going to turn it over to Royce, who's going to kick us off.
All guests have been muted.
Hold on one moment, please.
Can you hear me now?
I hear you, Roy. Yes, we can hear you.
Should I go ahead with and the slides as well?
Yeah. Yes, we'll move them forward.
Great, thank you. So I wanted to cover a few issues today that are related primarily to border security and issues related to, additional vetting, registry, and limited process at the border. So to begin, as everyone knows from the rhetoric on the campaign trail, border security is a major theme that we expect will be acted upon in the new administration. Despite promises to build a big, beautiful wall, the reality, of course, is that doing so will be quite costly and difficult. But we do expect that there will be increases in border security, likely in other forms of more electronic surveillance and drones, as opposed to as much brick and mortar wall, though I imagine we will see some wall building. Cost is certainly a key factor alongside logistics. I think we'll also see some increased staffing along the border, whether that's the allocation of National Guard troops, as has been done in the past, to the border, or some additional hiring, which of course will involve costs and time delays. So we may see some combination of the two. And then certainly we're expecting increased prosecutions of illegal entry and reentry at the border. And on the legislative front, we could see increased mandatory minimum penalties for those crimes. And as it is, the federal prosecution of illegal reentry cases takes up more than 50% of the docket, of the federal docket. And so we could see that grow even higher because some see this as part of the consequence delivery system that the Border Patrol tries to disincentivize or stop any kind of recidivism seen by repeat border crossers. Again, I do think that legislatively we will see activity on this front. I think they will try to do as much as they can with existing resources from the get-go. I do think that in terms of advice to those of you who are working with clients, just in general with the implications for travel being a little unclear, I know that many organizations are advising clients to, for example, certainly like in the context of DACA, if they have advanced parole to return before January 20th. That may extend beyond, the DACA population into just anyone traveling. I think that we're unclear what the vetting, how the shifts will happen and how quickly, and how emboldened CBP and officers will feel to enforce the law more strictly. Jumping to the next slide, to expedited removal. There are some who see the wall, as an ineffective border security measure so long as there are ways to get around it. If people can claim a credible fear of return to their country once they arrive at the border and be let in, then their wall won't be as effective as they want it to be. So we do think that they're going to try to minimize access to the U.S. immigration and protection systems, and increasing the use of expedited removal is a major way we're anticipating that they will do that. For those of you who don't know, expedited removal was created in '96, and right now only applies to those who are apprehended within 100 miles of the border and to those who entered within the last 14 days. And what it does is allow an immigration officer to make the decision to turn you around and remove you, as opposed to an immigration judge. What we are anticipating is that they may try to expand that, because the statute, allows for expedited removal to be applied to anyone up to who has been in the U.S. for 2 years, and could go to the entire interior of the United States. We are anticipating, again, some expansion or total expansion of that authority. We could also see it applied extraterritorially if they try to turn people around at or just before the U.S. border, for example, in Mexico, and try to do some pre-inspection to require people, if they do have a fear of persecution, to seek protection from the Mexican government, from their protection system. So one way or another, whether it's to limit due process in the interior, to be able to identify individuals throughout the country who can't demonstrate that they've been here more than 2 years, or to stop people from being able to even cross the border, we are expecting them to, using some existing administrative authority, expand expedited removal. The good news is it does not apply to lawful permanent residents. But there will be people who in a SWIFT process may have difficulties proving their status and presence. And so you may want to be advising your clients to be gathering their documents to show their presence, or that demonstrate their presence, and to keep those documents with them at all times. Moving on to refugees, which I think is part of this security conversation. We are expecting, right now there's a commitment to resettle 110,000 refugees through the U.S. refugee program in fiscal year 2017, which began October 1st. We are expecting a suspension of the program, either in whole or in part. Certainly for refugees coming from, what would be deemed a country of concern, such as Syria, but it could be from other countries that have majority Muslim populations. That could be done with existing executive authority. They could also just not claim a suspension, but apply what they would deem as some extreme vetting, even though refugees are already the most heavily vetted population among those immigrants coming to the United States. They could basically slow walk the adjudication so that many fewer refugees are actually admitted. And very specifically, the Central American Minors Program, which applies to certain children from the Northern Triangle of Central America, we are expecting will likely be ended, as those who are against the program have seen it as a way to route around the normal refugee processing and normal immigrant processing, and that it's facilitating smuggling of children. Finally, just to this idea of security concerns, many have talked about a registry. It goes by different names. What it did go as from 2002 to 2011 was the National Security Entry Exit Registration System, also known as NSEERS. And that existed in the wake of 9/11, where there were two forms of NSEERS, one in which individuals already in the United States, very specifically males of ages 16 and older, were called into immigration offices and basically told to report if they were from one of 25 countries, which was North Korea and other majority Muslim populations, majority Muslim countries. And as a result, about 85,000 people had registered, with over 13,000 being placed in removal proceedings. There was also additional screening from countries of concern at the border, and there's an unknown number of people who were screened that way. So we are expecting that some form of NSEERS will be resurrected. There are regulations still on the books, even though the countries were delisted and basically the regulation was made inactive. The regulation is still on the books and would be easy for the next administration to reactivate. So that program was suspended domestically in 2003 and at the border in 2011, but again, because of the conversations we're hearing very publicly, we are expecting some sort of registry and vetting. So with that, I will transition over to Jill.
Hi, can you hear me?
Yes, hold on one moment. So Ideen is actually the next presenter. So we're going to unmute Ideen.
Okay.
Okay, Ideen, you there?
Yeah, can you hear me?
Yeah. Go ahead.
Okay, perfect. Great. Thanks so much. I think looking at the immigration detention context specifically, President-elect Trump and members of his transition team have not spoken extensively or very specifically about immigration detention, although a lot of the immigration proposals that have been articulated in this 10-point immigration plan that he released, all of those kind of proposals suggest that we will see an increase in immigration detention. So one of the plans that he has proposed is that immigration officials will identify and detain anyone who has crossed the border unlawfully until that person is removed out of the country. One of the ways that we can see policy changes administratively happening would be specifically for arriving asylum seekers. We know that this policy plan would affect a large number of people, but we're particularly concerned of arriving asylum seekers because we know in the last few years especially we've seen a growing number of people coming to the United States fleeing persecution and torture in their home countries. And the policy under the Obama administration that was articulated in 2009 in a memorandum actually directs ICE, Immigration Customs Enforcement, to automatically consider for parole or to be released from custody immigrants who have passed a credible fear interview. So for a lot of us who do work with women and children who are coming from Central American countries, many of our clients have been released under this policy. Some of them on their own recognizance, others with bond, but we have seen an increasing number of people who are released from detention as a result of that policy change. That policy change also has articulated that it is in the public interest to release people who have passed a credible fear interview. Again, because this was a policy change, it's not in regulation, we do anticipate that this would be one policy change that could happen on day one. We know that there has been a lot of talk of reviewing all directives that have been issued under the Obama administration. This conceivably would be one of the ones that would be reviewed and could easily be rescinded as soon as he takes office. So that's something I think that we are very concerned about, and that we at this time aren't advising our clients about it, but it's something that we are monitoring very closely. One of, I think, the other issues that we are concerned about, and of course it has been one of the focus points of his immigration plan, has been that any individual who has some sort of criminal issue or what he has labeled criminals will be detained and will be removed or deported immediately from the country, right? I think we're still waiting to see who falls into this category, and of course, as president, he would have the authority to designate who falls as an enforcement priority. I think one of the caveats here, though, is that, I'm sorry, if we could go back to the last slide. Yeah, one of the caveats here is that while he could determine who is considered an enforcement priority, it would not be as easy for him to be able to just apprehend and detain the number of individuals that he has said he intends to apprehend, right? I think the most recent number he has said that there are about an estimated or at least 3 million immigrants in the country who have some sort of criminal issue and would be immediately deported. Under our current immigration system, the number of people who are detained is largely determined by the amount of funding that is appropriated to the Department of Homeland Security and specifically to ICE to be able to detain and remove individuals. So in order for him to be able to undertake the removal of millions of people immediately, whatever that means, if it's in the first year, however short of a period he intends to do that, it wouldn't seem feasible under the current allocation of funding for ICE that he would be able to undertake that immediately. So that would require a proposal on his part to expand the amount of funding appropriated to ICE. And we do anticipate that we would see a proposal, a budget from the president increasing the amount of funding to ICE. And given the makeup, of course, of Congress now, with the Republicans controlling both the Senate and the House, we think it's quite possible that they would approve an increase in funding to ICE to be able to do this. Although I'd be curious to hear from Jill and Royce, who kind of are on the ground in DC and might have a better take about the likelihood of this happening. Another thing I think that we have been monitoring, and it's really not within the legislative or administrative realm, but certainly it's something that could be impacted under this new administration, given that President-elect Trump will have the opportunity to appoint a 9th Supreme Court justice, is really the issue of bond hearings for immigrants who are in prolonged detention. Some of you may have heard that yesterday the U.S. Supreme Court heard oral arguments in the case of Jennings versus Rodriguez, which is a case that came up from the Ninth Circuit, and there's a similar kind of case in the Second Circuit where there is now a requirement in both of these circuits to allow for a bond hearing for immigrants who have been detained for prolonged periods of time. In the Second Circuit, within 6 months, and in the Ninth Circuit, at 6 months. So that case was heard yesterday. We've heard that it went very well, but of course, we don't know what the result will be. And if there is a split decision from the court, we do expect that the case will come up again. And of course, it will be heard at that point with a new 9th Supreme Court justice. And we think that the odds of getting a favorable decision there would be significantly reduced with a new Supreme Court justice. So that's something I think a lot of us are monitoring. There's certainly a lot of other cases that are coming up before the Supreme Court that deal with kind of the immigration consequences of criminal convictions that of course has a huge impact on who is subject to mandatory detention. And that's something that I think a lot of us are continuing to follow. But I think as far as if we can go on to the next slide, what we are doing and what we are kind of advising the community in our interactions. We visit actually 2 kind of very large detention facilities in the state of California on a monthly basis, and in communicating with immigrants inside of detention facilities, but also non-detained immigrants. One of the biggest things that we are advising people, of course, is getting information about any form of relief that they might be eligible for now to try to move forward with those other immigration relief options. And of course, for people who could be subject to mandatory detention because of a criminal conviction, seeing if they may be eligible for post-conviction relief. That is something that they can do now in order to avoid being detained in the first place. And there are a number of clean slate clinics that have been set up in California that are helping people look into these different relief options. We do screenings as well. We have found that doing Know Your Rights is really key. It's really essential, including in the detained population. We're actually doing kind of a big Know Your Rights training tomorrow for one of the detention facilities here in California. That continues to be such a huge need because many of the people who are in detention facilities aren't aware, if they haven't been screened for credible fear, but they do have a fear of returning to their home countries. We found actually just recently a large group of Haitian women who had not been screened and had actually already signed, had stipulated to their removal, and we were able to ask for an en masse kind of review of credible fear for them. And so that continues to be something that we see a need for, and in general, just funding to be able to coordinate those types of efforts. As far as kind of legislative and efforts, I think we do anticipate seeing legislation. We have seen this in the past with other immigration reform legislation efforts to increase the number of people who are subject to mandatory detention. I think it's quite possible that that would be something that we would see with legislation, and we are encouraging people, of course, to push back against those efforts. It certainly is one of kind of the most difficult issues to talk about in the community, and I think there needs to be a lot of education in the community about detention and who is subject to detention, but that's what we're doing in our organization at this time. Okay, so I think we can move on to the next speaker.
So Adina, I think you're up next. We're going to unmute you. Okay, Adina, I think you're unmuted.
Can you hear me?
Yes.
Great. Thank you so much. So I want to start off talking about this idea of the criminal immigration detention deportation pipeline that is already massively funneling immigrants through the criminal system to deportation currently under President Obama, and we of course anticipate will be rapidly growing as it has been for many years. Currently, this is the main way, at least interiorly, that people are deported is through exposure to state criminal systems and then apprehension through ICE, either through detainers after criminal court, at the completion of sentences, or when people go to their probation appointments. So right now, the majority of people we see detained here at CARE Coalition have come into ICE's radar through some kind of touch in the criminal system. And the deportation process is already highly entrenched across both systems. So it's a huge problem that we already have, and we anticipate increased collaboration between actors in both systems on the local level that is going to need to be challenged. Another big issue is the elimination we expect of priorities for who is picked up by ICE for deportation in the criminal system. Under Obama, he has established some priorities that define very narrowly and specifically what types of so-called criminal aliens will be picked up, and oftentimes those priorities do require a conviction. However, there's large swaths of people who often fit under those priorities. They're very broad to begin with, including many lawful permanent residents or LPRs who have minor criminal histories. We know through Trump and his counsel's rhetoric that they are seeking to define this term criminal alien in terms of priorities as anyone who essentially gets an arrest. So for immigrants who are in lawful status and are not deportable due to convictions, we don't think they would be picked up. DHS is still going to need to adhere to the criminal grounds of removability, at least at this point, while they remain law or not changed. But people who do become deportable due to convictions and have lawful status, we expect will be apprehended at increasing rates. In terms of undocumented immigrants or immigrants who have gone out of status, we expect the expansion of who is going to be picked up in terms of priorities and in terms of just being arrests. So we saw this back in 2011, 2012 with President Obama, and people were immediately detained for simple arrests such as driving with a broken taillight. And Royce already mentioned as well the expansion of expedited removal. We expect that to be increasing as well. In terms of legislative changes, the 96 Illegal Immigration Reform and Immigrant Responsibility Act, or IRA, has drastically expanded the number of criminal offenses that do trigger deportation and cemented an extremely broad category of criminal offenses under federal immigration law. At this point, many state offenses, ICE routinely charges as removable offenses that are oftentimes legally unsound. But under the current system, people are detained without possibility of bond, barred from defenses of deportation, etc. And now here we are 20 years later, and we expect this legal framework to further develop and expand under the new administration, including the criminal grounds of removability. In terms of the media and what we're hearing about this idea in the public conscious that's been deeply entrenched for many decades now about the criminal alien, that is going to be rapidly increasing. It already has under Obama with the idea of felons, not families, and throughout we've seen now in Trump's campaign depicting all immigrants as criminals. So we think there's going to be a huge need to resist this narrative and keep pushing back on that story and humanizing the population. So next slide, please. So that was a pretty bleak picture in terms of criminal immigration, but there are a lot of interventions that can be made at this intersection of criminal and immigration law. It's extremely complex to do so because the system spans the legal frameworks in both the criminal and immigration worlds. So the interventions need to be very strategic and intentional and specific. Thankfully, through the Equal Justice Works Fellowship here that I'm doing here at Care Coalition, we have been able to develop a lot of innovative interventions that we hope we can collaborate with more providers around the country to be increasing and exploring how we can push back in specific ways in these systems. So I want to talk about a few of them. First, in terms of the criminal system, you can view that sort of what can be done prevention-wise. This is extremely important to be limiting the number of people who are exposed to ICE through the criminal system. And there's a Supreme Court case, many of you know, Padilla versus Kentucky, which requires criminal defense attorneys to advise their immigrant clients of the immigration consequences. However, in most of the country, there's not much being done at the state level to ensure Padilla. So it's crucial to be providing Padilla advisals, increasing funding for that, and preventing the number of people who enter the system at that point, at the stopgap. In terms of what can be done in the immigration system, there's a few things that are super important at the intersection of criminal and immigration law. It's crucial to be training pro bono attorneys in the intersection of criminal and immigration law. There's a big misconception that pro bono attorneys would never be interested in representing an immigrant with a criminal conviction. But we've been seeing that's actually not true. The private bar, through specific outreach, is really interested in this area of the law. There's a lot of benefits to doing it, appellate experience, and being able to change the law rather quickly through establishing new precedent. The other thing that can be done in the immigration system that we've been trying out the past year is impact litigation. So challenging what state offenses ICE designates as removable offenses and as bars to relief under federal immigration law. The law in this area has been evolving very fast and to the benefit of immigrant communities at the Supreme Court and the circuit courts. The problem is really it's not being applied at the lower levels by immigration judges and often the board. So there's a lot of opportunities to make cutting edge arguments and actually challenge whether an offense makes someone removable or bars them from a defense. And doing so helps at the front end in the criminal system by increasing the number of pleas that are immigration safe, and that public defenders will have more options for their immigrant clients to avoid getting into the deportation pipeline. So kind of making a feedback loop. And then what we would also propose is thinking more about holistic defense across the criminal and immigration system. So essentially teeing up when public defenders are able to advise their clients in criminal court about immigration consequences, making sure those arguments that are preserved are carried out in immigration court by an attorney who's trained in the intersection of criminal immigration law and can then carry out that defense. It requires a lot of collaboration, but I am hopeful that this is an area we can be growing in and fighting in the coming years. In terms of legislative, I think the crucial point here is really preventing growth of IRA. That's has been extremely destructive for increasing the number of offenses that trigger deportation. Next slide, please. So I want to talk quickly about what we can be telling the community and our clients at the issues at the intersection of criminal and immigration law. The first point is Know Your Rights workshops should really be mentioning this area and not just talking about preventing Fourth Amendment violations at seizure and arrest, but also the inherent constitutional rights of immigrants as criminal defendants. It's important because the harsh reality is that so many of these convictions, as I've been mentioning, in the criminal system will trigger deportation for our communities. And a lot of people are shocked to hear that they can be deported due to a misdemeanor plea. There's very little public awareness about this, and it's something that the community has a right to know about. So we encourage that to be a big part of Know Your Rights, and also informing people about PDEA, and that if they are accused of a crime, their public defender, their criminal attorney should be able to tell them very specific things, such as how their plea will trigger deportation or affect their immigration status. And knowing it's not enough to just say you might be deported or maybe you should talk to an immigration lawyer. With our clients, there's things we can be doing to empower people. For example, making clear that the law in the courts of what offenses trigger deportation is separate from the political branch actions. We still have the courts to rely on, and the tool of the categorical approach, which is the method of analysis to analyze convictions in immigration court, explaining that area has been developing to immigrants' favor, and it's important to hold ICE to its burden. It's their job to prove if an immigrant is removable. It's also we should also be pushing back on substantiated allegations. For example, we're seeing so many immigrants labeled as gang members without any evidence at all to support that. The last point is understanding that the process of increasing the number of offenses that are not removable offenses through litigation takes time. And for people who are detained, it's important to manage expectations and empower people to make that personal decision if it's worth it for them to fight going up on appeal. Lastly, in terms of the media, as I mentioned, I think it's really important that we show the human face of people who are being labeled criminal aliens, and focus on due process in our criticism, especially if DHS is expanding expedited removal, increasing the number of people who don't have the right to go to a judge, and people who don't frankly care about immigrants do care about due process, and they are concerned when they learn about the sham of the immigration system that we have. So that's a powerful tool. And the last thing I'll say is just to remember, with due process, we do win cases. So the ability to keep fighting in court is the ability to keep defending our clients and our communities. So with that, I will hand it over to the next speaker. Thank you.
So Jen, I think you're up next.
We're going to unmute you in 1 second. Okay.
Hi, can you hear me?
Yes.
Great. Thank you, everyone, and thanks for including me in today's webinar. I'm going to focus on the population of unaccompanied children who have been arriving in the United States and what we foresee and can predict the reaction. I wanted to start off with this slide that shows the numbers just because I think this is really important in terms of the context. I mean, as we all know, for years there was a relatively small number of unaccompanied children coming to the United States. It's not a new phenomenon, but it gained attention in 2014. Unfortunately, with attention came criticism, and that's when we really started seeing a trend, particularly coming from Congress, but also from the administration in terms of considering rollbacks of important protections for these kids. Now, there was a slight decrease in fiscal year 2015 that was mostly due to the increased interdictions by the Mexican government. So there was a dramatic increase of children being apprehended and deported from Mexico, so they were never able to make it to the United States. Fiscal year 2016 again jumped to the second highest number ever on record, and the numbers have not slowed down since the end of fiscal year 2016. October, November have had incredibly high numbers. And what we're seeing right now is in order for the government to be able to process them and not have backups at the border like we did in 2014, the government has quickly been opening emergency facilities and shelters to deal with them. Right now, we're going to have 2 emergency facilities that are being run by Customs and Border Protection that are going to be kind of like refugee camps, so soft-sided tent camps down along the border where they're going to be putting mostly unaccompanied children in family units who have been traveling together, so parents with children. And we're going to soon have 3 emergency ORR facilities. So that's going to be on top of the network of facilities that ORR already has around the country. That's going to hold thousands of children. So not only is CBP struggling with the reception down at the border, but ORR is as well to ensure that kids are not piling up and languishing in these CBP facilities. I wanted to give that context because, as you can imagine, with the increase in numbers, again, just like in 2014, there's an increase in attention. So the media is starting to report on the high numbers again. This was a topic that came up yesterday. The new chief of the Border Patrol testified before a Senate committee yesterday, and the issue of the numbers of kids and families at the border was incredibly contentious, and again, ideas to roll back protections as a way of both dissuading future refugees from coming, but also as a way of processing people more quickly came up. We're really worried about what all these proposals are and the likelihood of success considering the makeup of the next administration and Congress. So we can move to the next slide. I just wanted to break down, some potential risks that we're keeping our eye on with administrative changes, legislative changes, and appropriations and funding changes that we suspect might be coming down the pike. One big one that has been outlined both in some literature from restrictionist groups as well as what we have heard from several Republicans on the Hill is this idea of making some sort of either administrative change or a change in the interpretation of what an unaccompanied alien child is. Now, we all know the definition comes from the Homeland Security Act, And there's one part of it that says a child is unaccompanied if there's no parent or legal guardian available to care for the child. And so the question is, what is available? Traditionally, this has been interpreted as, at the moment of apprehension, is that child with a parent or legal guardian? And if they're not, if there's no one available to take care of them in that moment, that's when the definition of UAC attaches to that child, and the protections that attach with the definition stay with that child. So even if down the road they're later reunified, or they leave ORR custody and they go live with a sponsor, the protections that attach the moment the child is designated as a UAC stay. Now, we're already starting to see this a little bit, particularly with children who've been apprehended in the interior of the country. If through some sort of contact with the juvenile justice system. There have been debates and a movement towards defining these children as accompanied, and that's really important because that means that they would not go to the ORR would not be responsible for the care and custody of the child. It would be ICE, and so we would have more and more children going into ICE custody, not just in the family detention facilities, but also in the adult facilities. So we're really concerned about that and want to keep an eye on it. Both should there be some sort of formal policy change, but also just what all the field offices are doing. In terms of legislative changes, I think we've seen proposals over the past few years coming from both the House and Senate that I think are going to be revived. I think the main one under attack and one we all keep talking about and thinking about are the protections for unaccompanied children that were outlined in the 2008 reauthorization of the Trafficking Victims Protection Act. Those include the one-parent SIJ eligibility, the idea that a UAC has an opportunity to make their asylum claim in the affirmative sense before they would have to go to court and do it in a defensive posture. And also this idea of what a contiguous country is. All children who are from contiguous countries, so currently it's Mexican and Canadian children, they are allowed to withdraw their application for admission at the border. And so after following a very cursory screening done by CBP, a Mexican child can just be turned around immediately at the border. Since 2014, when we saw the backup of kids in Border Patrol stations, this idea of expanding the contiguous country definition to Central American countries as well has been floating. We're really afraid that this is going to rear its ugly head again in legislative proposals coming out of the House and Senate. The importance is that when a child is returned immediately from the Border Patrol station, besides the logistics of how that would work and how long a child would have to remain in these inappropriate facilities, is that they would never have the opportunity to get a Know Your Rights presentation. They would never have an opportunity to get a legal screening. They would never have an opportunity to tell their story to a judge, and it really curtails a child's ability to make a claim for protection. And we know so many of these children who are coming from Central America are coming seeking protection in the U.S., so we're extremely concerned about that. The final thing I'll say is thinking about the funding threats for legal programs. There are legal programs currently that are funded by HHS as well as DOJ that provide funding for direct legal representation, that provide funding for pro bono facilitation for representation for unaccompanied children, for LOPs, for LOPCs, for legal orientation programs, both for adult detained individuals as well as for custodians who will be sponsoring a child out of ORR custody. A lot of these, although they're provided for in the law, are discretionary. And so should there be funding shortfalls, should there be riders on any sort of budget proposals moving forward, we really need to keep an eye on and protect the small amount of money that are going to these programs, because although we're not quite close to meeting the need in terms of representation for these vulnerable populations, we've really come a long way in the past 8 years of increasing representation for these kids, and so we want to make sure that they're not snatched away through any sort of funding proposals. I will leave it there. The next slide, I just have my contact information. Kinda is working on talking points and educational materials so that our colleague organizations can use them freely and work both with local policymakers and advocates, as well as on the national scale when people are doing their advocacy. So I'm happy to share all of our materials as soon as we finish them, and people should feel free to reach out to me directly as well if they have questions or want something that they feel like could be helpful in their advocacy. So thank you, and I will turn it to, I think, Jill now.
Yes, thank you so much, Jen. We are just going to unmute Jill in a mere moment.
I think we're there. Can you hear me okay?
Yes, we can hear you. Thank you, Jill.
Great, thank you, and thanks to everyone. I have just a couple of slides, and I'll try to keep it short given the time that we have. We're moving on to executive action in this part of the webinar. And I'm assuming a little bit of knowledge, but we'll present understanding that some may not have as much knowledge about the executive action programs. We'll start off with the first slide, which focuses on DACA. President Obama, through executive action, announced the Deferred Action for Childhood Arrivals program in June 15, 2012, a date that resonates in my mind forever. In the 4 years since, DACA has become one of the most successful humanitarian immigration initiatives in modern history. It has provided protection from deportation and work authorization to over 740,000 people who are now able to live more freely, attend school, get jobs that allow them to be self-sufficient, and even provide for their families, and obtain driver's license and cars that improve their mobility and opportunities. So that was the case until the election. During this series of presidential campaign, and in his contract with the American Voter, and now on the transition website, which is www.greatagain.gov, President-elect Trump has indicated that he intends to end President Obama's executive actions on immigration. That would include DACA, which was the initial executive action in 2012, as I mentioned. This initiative is currently, initiative is currently listed as the 5th priority on his immigration policy page. We note that higher on the list are priorities that are found on greatagain.gov are building the wall, as has been mentioned, ending catch and release, and focusing on criminal aliens, which has already been discussed. At this time, little is known of what lies ahead for DACA for this administration, but we think it would be counterproductive to terminate the work authorization of, as I mentioned, almost 750,000 employees who are contributing to U.S. businesses. They're supporting themselves and their families. They're paying taxes and contributing to our Social Security system. In fact, the ILRC is publishing a report that indicates businesses could incur $3.4 billion in turnover costs. And that's the cost associated with, termination and replacing a valued employee. So it seems that it would be counterproductive and counterintuitive, but we really believe that we need to take the president-elect at his word at this moment, which has been nothing but indicating that he does intend to terminate DACA and prepare our community for what that may look like. In an ideal world, DACA, which was intended to be a temporary initiative, would continue until there is a legislative solution. We know just, I believe yesterday, Senator Lindsey Graham indicated that he is working with Democrats and Republicans to prepare a Dreamers bill for the next Congress that would provide a bridge for folks who hold DACA to whatever is next to come. We don't know what that will be. The plan that was discussed by Senator Graham would apply just to immigrants who have been approved under this current 2012 directive from President Obama. So we'll see where that goes. Acknowledging that, so ideally that would be the bridge filler, and that would provide protection to our DACA recipients out there. But knowing that we really don't live in an ideal world, we really do need to prepare and think through what termination of DACA could look like. So there's a couple ways that the rescission could happen, and I think many iterations there within. So rescission could come obviously on the very first day that President-elect Trump takes office. It doesn't seem that it's that high on his priority right now, but things are changing very rapidly in this transition team. So again, we prepare for the worst. So the rescission could go through sort of a USCIS process where notice would go out to recipients, and they would be, essentially told that they would need to turn in their documents, kind of, I think, similar to what that DACA recall looked like about a year and a half ago. So again, this would take some time. We all know how quickly, a little tongue-in-cheek there, that USCIS can move, but that would be quite a large initiative for USCIS to contact that many applicant or recipients for DACA and send that many notices. And of course, they would have an opportunity to respond. So this is a iteration, I guess, of how a DACA termination would look like. There could be a phase out of the program, meaning on a date, a designated date, the USCIS would be, informing individuals that, they would not be accepting any new DACA applications, and then those who hold DACA currently, essentially, they would hold that the protection from deportation and work authorization until the time that it expired, and that there would not be an ability to renew. So that's another, it's called the phase out, I guess, way. And of course, the worst case scenario is that DACA recipients would be issued NTAs, and that would take the time of transferring data from which is currently stored in USCIS over to ICE, and again, the time that it would take for issuing over 700,000 notices. So those are some of what it could look like, termination could look like. Again, there's lots of things in between. But with all these unknowns, we understand that it's pretty difficult in this climate to advise clients on what they should do. Many organizations like Clinic that are in the position of providing technical guidance and assistance to representatives, we're taking a cautious approach on supporting our network and advising on how we're advising that there should be individual consultation that really focuses on risk assessment and what are those risks, taking into consideration the revelation of personal data, for example, for a new DACA applicant. That would be a pretty high risk, right, for someone to reveal all of their personal information, sometimes information about their family members in that application. So you'll find that a lot of national level organizations and grassroots organizations are cautioning against new DACA applications because of that. Again, another risk is the loss of the $465 fee for the application, which is extremely significant for low-income immigrants. If the president-elect was to end the program today, essentially there could be, and you have a pending case where the government has already accepted the fee, that fee could be a complete loss. So that is, again, it's a very significant amount of money for many individuals. I've been in the immigration field, I guess, for well over 15 years now, and this time of uncertainty really reminds me of the time following September 11th terror attacks and the crackdown on immigration and entry to the United States that ensued thereafter. Like then, I think it's important now for practitioners to really own and acknowledge the uncertainty and fluidity of this moment. in some consultation circumstances, you may not be able to have any definitive answers to share with your clients. You may need to reschedule a check back in once things are more solidified. That check-in may have to happen several times, as this is really an evolving process. So I think understanding that we don't have all the answers, acknowledging that and sharing that with our clients is very important. It's also important to think, if you are an organization that produces materials that are being sent out through social media or posted on your website, that thinking about your resources, you may have to update those resources several times and make sure that the wording is appropriate. Clinic is offering some resources that are downloadable and able to customize and use, and we'll be adding more resources. And again, we too will be updating our resources as we hopefully know more. One thing we recommend is don't stop. Be there for your community. Even if you don't know the answers, say it, you don't know of the answers. But think again about screening individuals who are coming to you for assistance in terms of maybe potentially applying for a new initial DACA application. Maybe they under your consultation have decided that it's just way too high risk right now, but make sure to screen for other benefits, because we know through studies that nearly 15% of individuals who were screened for, I think it's expanded DACA and DAPA, were found to be eligible for another more permanent immigration benefit. So don't forget to think outside the box, think creatively. And again, Clinic has some resources that will help you to think about those other immigration benefits. We're putting together a screening tool that could be used during workshops that we hope to have uploaded very soon to our website. So keep a lookout for those things. And don't forget to rescreen your DACA renewal applicants, as we know the circumstances of any individual can change over time. Again, keeping that engagement going during this time is important. There's a lot of fear and anxiety in the community, and we think this is an opportunity to empower individuals by conducting Know Your Rights presentations that's been mentioned, and don't forget to ensure that you are having presentations and emphasizing the hazards of immigration scams and notario fraud, which just seem to run rampant at these types of times. So given the fluidity of the situation, that's what we have to offer on DACA at this time. We'll move on to our next slide, which is just to get us to think a little bit about the other executive actions. While most of the focus has been on DACA, this existing program that remains in effect right now under the Obama administration. So if you've got your renewals, think about your renewals going in. Most of the focus has been on DACA, but it's worth noting that President-elect Trump's promise is to cancel, and this is quoting, cancel unconstitutional executive orders and enforce all immigration laws. And this is, written on the Great Again website. Clinic's position, and I think most of the organizations that have joined on this webinar today would say that none of President Obama's executive actions on immigration, whether it be the 2012 DACA program or his 2014 executive actions on immigration that included the expansion of DACA and deferred action for parents of Americans, the visa modernization initiatives, the efforts to promote naturalization, and the expansion of provisional waivers. None of us are going to say that those were unconstitutional. Clinic and many other national groups take the position that the president was well within his authority to issue those actions. So it's not clear what the Trump administration will consider unconstitutional and actionable under their policy, but it's very likely that DAPA and expanded DACA, the most controversial, will not make it through the courts. So I think we'll move on from that. I just wanted to, since we were talking about all executive actions, make sure that we we discuss those other, the 2014 executive actions. We'll move on to sanctuary cities. As you can imagine, Catholic Legal Network being part of the network we are, supporting Catholic and faith-based organizations, we get a lot of questions about what the term sanctuary, as it does originate from religious and immigration-centered movement in the 1980s. And there's been a great amount of talk of sanctuary cities and sanctuary campuses, and so we thought it was important to include this. There's really, in terms of what is a sanctuary city, there's really no universal definition for that. Essentially, it's used to describe localities that limit the role of local police in enforcing federal immigration law by prohibiting, limiting compliance with ICE detainers and requests for notification of a person's release date from local police custody. With respect to how many jurisdictions are considered sanctuaries, there are well over 30 major cities and overall over 400 communities across the United States. That includes counties, which can be quite large. The big cities include San Francisco, Santa Fe, Seattle, Oakland, Los Angeles, New York, Chicago, and Washington, D.C. There's many, many, many on that list. But generally, why? Cities and municipalities generally adopt these policies because they're considered to make their community safer, actually, and to protect the individuals from violations of their constitutional rights. We have received here at Clinic, we have a state and local project that has been inundated with requests for how can we become more welcoming community. So we're heartened by that, although yes, it's a lot of answered calls and emails, but we're just so heartened that there are municipalities, there are cities, there are college campuses that are considering the concept of sanctuary and wanting to really protect their student body with respect to schools and their residents when it comes to the municipality. So it's very heartening to see that those efforts. We have Clinic has a Sanctuary Cities Toolkit, which gives a little bit more information about the federal policy, what state policies can choose and what their choices are, and kind of the public policy arguments and talking points. So that's included in our resources that are at the end of my section of the presentation. So we encourage you, if you are living, and by the way, knowledge is power. You should know whether you are advising clients who live in a sanctuary area or an area that actually does have an agreement with the federal authorities to what's considered 287G MOU. So please look out for those resources and know what jurisdictions to advise your clients about. So really nothing in the federal law. I guess one of the questions, to go back to the sanctuary cities, of course, I think we've understood the type of framework or essentially what a sanctuary city is, in that it involves local police not enforcing certain federal immigration law. So really, I guess the president-elect has decided to even higher priority than ending the, again, quote-unquote, unconstitutional executive actions, even higher than that on this list of immigration policy priorities, President-elect Trump has indicated that he would like to end the use of sanctuary cities and end sanctuary city policies. And the way that he's suggesting that he could go about this is to cut off federal funding to those jurisdictions. And so that is the threat. It's actually listed on number 4 of the priorities in his in his contract with the American Voter and on the Great Again website, which is to block funding for sanctuary cities. So that raises some constitutional questions of whether that could happen, and there have been a lot of news articles released over the past few days. But many legal scholars and the cities themselves are taking the position that blocking all federal funding to a sanctuary city would violate the Constitution, and they're definitely pushing back on that. So we will see how that goes and that develops. And I think Clinic would take the position as well that cutting federal funding would be unconstitutional. And what is the difference then between a sanctuary city and a sensitive location? We'll get to that to the next slide, but I wanted to share with you the next slide just very quickly is to give you, again, it's sort of this, we need our positives where we can find them. This is on Clinic's website, and it's a demonstration of how many, and it's a little outdated, we're going to update it, how many cities have declared themselves sanctuary cities and municipalities that are out there, and how much legislation has been to become sanctuary cities has been introduced in 2016. So this is very heartening that there are so many jurisdictions that do wish to become more welcoming and to protect their immigrant brothers and sister residents. So I just wanted to share very quickly that, and we'll be updating that again after after the legislative session, which will start in January 2017. So we'll move on to the next slide to drill down a little bit more on what are sensitive locations. I'll go through this very quickly because I know we want to take some questions here. So sensitive locations. So when we talk about sanctuary cities and sanctuary campuses, that's a big movement right now. There's, all these petitions out there for colleges to become sanctuary campuses. And again, this is just so heartening that colleges want to protect their faculty as well as their student body through these initiatives. And essentially what a sanctuary campus would look like is, a school or a campus that institutes policies that help to protect the identity of students and, ensure that any local campus law enforcement or police would not, willingly collaborate with ICE. So those are what those policies, and there's many, many other policies that campuses can look at to strengthen themselves as institutions, but also to the protections that they offer to their students and faculty. With respect to schools, campuses and schools, we note that under a 2011 memo, the DHS Sensitive Locations memo, schools are already considered what is considered a sensitive location, right? Schools, hospitals, churches are considered sensitive locations. And what does that mean? It means that that's where ICE should avoid enforcement activities. ICE already treats campuses as sanctuaries where immigration enforcement should be handled with what they consider extreme caution. But I think the sanctuary campus movement is really still a wonderful initiative. And again, we don't know what will happen to this 2011 ICE memo following the inauguration. So it's a memo that's in place right now. But again, back to the unknown, and it's an evolving situation. Our next slide is just a list of the resources that I've mentioned, and there's more on Clinic's website. If you need anything, if there's anything that we can offer to you, please don't hesitate to contact us at advocacy@cliniclegal.org. We are here to listen and to respond to our community needs, so we encourage engagement. And again, we have the URLs for several of the resources that we've already indicated, and the Preparing for Changes in Presidential Administration part of our page will be updated every other week unless there's been a major breaking news, if you will. So just keep looking at that website for new resources every day. And I should mention that many of those resources will be available in Spanish, and we hope in Arabic in the future. Okay, so I think we'll move on to questions. Ladies?
Thank you so much, Jill, and Royce, Eileen, Adina, Jen, and Jill. We so appreciate your time and all of this great information. I'm sure that outline of potential implications was as difficult for you all to get through as it was for us all to hear. We will be circulating the slides and a recording of the webinar so everyone can have access to these resources. Before I unmute the lines for Q&A, I just have a couple of really quick housekeeping notes. When we unmute the line, if you could just make sure if you're not speaking that you are individually muted on your phone just to avoid background noise so everyone can hear. Secondly, if you need to leave this call to take another call, please just hang this line up. Otherwise, we'll get hold music and it's really disruptive, so just please be mindful of that if you need to get off the line. And finally, if folks could say their name and their organization or affiliation when they speak, that'll be really helpful for the record and in case anyone wants to follow up with anybody else. So if you could just please do that, that would be great. So with that,
All
we're going
guests
to
have been muted.
unmute
All
all
guests
the lines,
have been muted.
including our speakers, so that folks can ask questions.
Anybody can jump in right now. You can also, if you're signed in on your computer, you can also type in questions through the messaging function and we'll read them.
This is Jill. As we're waiting for questions to come in, I wanted to, I just received a question via email from an affiliate who was seeking some guidance on how to advise a client who wants to travel, who has DACA and wants to travel. They have an advanced parole already approved for travel, and they're wondering whether that is a risky proposition. Again, we at Clinic appreciate that this affiliate's looking at it from this angle. They're trying to get technical assistance, and really they're engaged in the individualized consultation that we think is very important to review each individual's circumstances to determine whether that proposal would be for travel would be in their best interest. Generally, from a Clinic perspective, we are advising that travel could be quite risky the closer it gets to the inauguration. Certainly, individuals will want to be back in the country well before the inauguration. Understand that there's a lot of folks at Customs and Border who have been sort of waiting for this moment for things to change, and we do anticipate that it could become more difficult for individuals to re-enter even if they have a valid advanced parole. So we are encouraging individuals to get that travel done as quickly as possible, if it's even advisable to travel, noting that there could be a potential benefit for readmission under advanced parole. But it's really important to understand that CBP is at CBP's discretion to readmit individuals, DACA applicants or DACA recipients under that advanced parole travel document, and we really do recommend that individualized consultation. So I just wanted to share that.
Hi, this is Eliana. Can you hear me?
Yes, we can.
Okay, great. So my name's Eliana. I am from SEIU, California, and I have a question because we've had several members who have TPS status who are very concerned that that may be on the cutting block, and I'm just curious if anybody's heard of anything related to TPS, specifically for Salvadorians, I guess.
This is Jill. I can start, and I welcome our other panelists to join in. We have not heard anything specifically. If you go to the policy pieces, that the very limited information that we have on the President-elect's website, transition website, there's nothing specifically saying TPS will be, taken away forever. But there have been some individuals within the transition team that, in their capacity in the transition team or in their former capacity, have definitely been less supportive of TPS, particularly TPS over long periods of time. So that is something important to consider. What else is important to consider from a practitioner standpoint, from a representative standpoint, is how does it happen that TPS would be ended? What are the mechanics of that so that individuals who currently hold TPS, who, if TPS was not redesignated, what would that look like? And typically, it could be a phase out where, they're just not going to redesignate. But typically there is notice through the Federal Register when a program will be, TPS will be designated or not, redesignated or not. And so individuals would be given some time. And if you look at the most recent example of the mechanics of that, you can look at the TPS for Ebola-stricken countries and how that looks essentially, where individuals have been given a period of time to understand that their TPS will end on a date certain, and that during that time they are able to make what the plans that they need to in order to either change to a different status or plans to leave the United States. But it isn't a very long period of time, I can tell you, but it's certainly not with a stroke of a pen and it's all gone. Anybody else want to advise on that?
So I have another question from Valeria Gomez, who's a Justice AmeriCorps Fellow at VITA in Knoxville, Tennessee. And I think this is for Royce. When you mentioned that the U.S. could enforce expedited removal on the Mexico side of the border, forcing people to seek asylum in Mexico, would that be pursuant to a bilateral agreement with Mexico? Otherwise, what is the statutory authority for CBP to enforce U.S. laws outside the country?
Mm-hmm.
Royce, are you there?
Hi, yes.
Sorry,
No problem. I apologize. I was going to chime in on the TPS question as well, but I couldn't get unmuted.
Please do. Please do. Yeah, you were on mute for some reason, so please do that.
To your question about expedited removal, and thank you, Jill, for answering the TPS question. To your question about expedited removal, I mean, it's actually a question we're looking somewhat closely at. You are correct that one of the ways in which expedited removal could be pushed into Mexico would be through a bilateral agreement, which is something that previous administrations have not been willing to press Mexico into doing. I think obviously we could imagine that the incoming administration would be eager to leverage Mexico on a range of issues, whether it's NAFTA renegotiation, remittances or other, aid type issues to apply new pressure points in that conversation. So I can't say that we could take a bilateral agreement off the table. It is also conceivable that through legislation, there could be a finding that Mexico would be a safe third country and would have the same effect. So it would be a more unilateral move, but it would have the same result where individuals would get turned around. This would enable some pre-inspection, as is done in other places, in Canada and Dublin and the United Arab Emirates, where inspection is done far from the actual border, but in advance. So that the idea being that where people would get turned away would be a safe place for them to then seek protection. There are separate questions given that Mexico is a signatory to the Refugee Convention and has obligations not to return individuals to harm, whether that could be invoked, whether there could be application of firm resettlement, making allegations, even if it seems to us as a stretch to suggest that someone who's passed through Mexico is in any way firmly resettled there. We are sort of contemplating an administration that sort of takes action first and litigates later, and that the threat of litigation wouldn't be a sufficient deterrent. So there's a few different ways. I mean, we share your question about what the authority is, what they might do even in light of questionable authority, and what pressure might get placed on Mexico to agree to some version of this. And of course, there's simply the idea that they would just turn them around at the border, that they don't actually operate well inside Mexican territory, but that they hold at the border and turn people around at the border or limit access, as we've been seeing in some places like San Isidro and other places in Texas lately.
Thanks, Royce. And did you have anything to add beyond what Jill said on the TPS question? We're sorry, I don't know why you were muted.
No problem. No, I mean, I think Jill largely captured it. It's just that the authority is broad, and the expectation is that the new administration would either terminate immediately or, this is very similar to the DACA conversation, terminate immediately, and the employment authorization would follow, as if someone's employment authorization is only as good as their status. Or that they would just fail to renew, so that as each individual designation was due to be revisited, they would terminate it in each of those instances. Jill mentioned that in the past, other designations have been given sometimes an extension or some sort of a grace period to prepare their next steps. I am not as optimistic that under this next administration we would be given that sort of grace. And I don't think any one particular TPS designation would be targeted over the others. I suspect that they would, could be targeted across the board.
Thank you, Royce. I think we have time for about one more question. So you can either type into your chat box or speak up on the phone. Well, hearing no more questions either coming in through the chat box or on the phone, we just wanted to take another moment to thank everyone for their participation, especially to our 5 wonderful speakers. We really hope to keep the conversation going, and as I mentioned, we'll be following up with the slides and the recording and some additional information in moving forward. And just thank you all so much, and have a wonderful afternoon.
And thank you all for doing the work that you're doing.
Thank you.